Welcome LML 4807 students to this online lecture. In this online lecture, we will discuss smart cards and e-money. The content of this lecture is found in lesson 9 of your study guide. We will now discuss the development of smart cards. Plastic paying cards were developed as an alternative to carrying money in a form other than cash. The plastic paying card had a magnetic strip on the back of the cards and was considered as the standard security backbone for the cards. New technology has replaced the magnetic stripe with a microchip known as a smart card chip, hence the term smart card when referring to the plastic paying card. One of the few disadvantages of introducing the chip or smart card was the initial cost involved, not only in replacing existing magnetic stripe cards with microchip cards, but also in providing the necessary hardware. This necessitated, for example, installing microchip compatible terminals at points of sale, for example at a supplier's premises, and upgrading existing ATMs to accept chip or smart cards. Currently, most South Africans make use of such smart cards. Further, contactless smart cards were also introduced, referred to as a tap-and-go payment. These networks are operated most probably by Visa or MasterCard. A customer is able to pass the smart card close to the electronic reader at the merchant's pay point. Usually, if the transaction is below a certain amount, the customer need not enter a PIN for verification. However, larger transactions will still require PIN verification. We will now discuss e-money or the electronic purse. Included in the concept of e-money is e-money cards, or known as electronic purses. E-money, or the electronic purse, is an important example of the use of chip or smart cards in the banking sector. The electronic purse is a card with a computer chip embedded in it that it can be charged by a bank or other issuer with part of its client's current account balance or credit limit. This enables the cardholder to use and record a series of transactions until the available balance on the card is exhausted. The bank or other card issuer may then recharge the card. The card chip stores the cardholder's PIN and provides the verification for it when the card is used in a machine. The electronic purse allows clients to buy goods at participating retailers and to obtain other services, such as making or receiving phone calls, bus rides, car parking, and borrowing library books, to mention but a few uses. The advantages of payment effected by way of an electronic purse is that it is anonymous and fast. The money is transferred directly from the electronic purse to the receiver, and it is instantly available. A PIN or signature or verification is unnecessary. The use of e-money is not yet regulated. The written terms and conditions of the contract between the issuer of the e-money, usually a bank, and owner or bearer of the device, the consumer containing the e-money, will therefore determine the rights and the obligations of the parties. It must be mentioned that technology is available that entails an e-money transfer service using a mobile device. Customers do not require a conventional bank account. Customers can deposit, withdraw, send money to anyone with a cell phone within the boundaries of a certain country, buy airtime, and pay for certain goods and services. We will now discuss the influence of smart cards and e-money on the bank-customer relationship. The use of smart cards and e-money has resulted in a number of novel legal issues. We will now consider some of these issues. Let's first consider the countermanding of payment. It is currently not certain whether a cardholder would be entitled to countermand a payment instruction made with an electronic purse. Because payment with an electronic purse involves real-time and unconditional payment with a cardholder's own money, that is, the credit units loaded onto the card, practical difficulties may arise if the cardholder wants to countermand payment. Because payment has already taken place by the time the card issuer receives the instruction from the cardholder to countermand payment, the card issuer or the bank will then have to become involved with the underlying contract between the cardholder and the supplier. In other words, the bank will then have to claim the money from the supplier. This obviously poses practical problems, and it is highly unlikely that the card issuer will be prepared, in the absence of fraud or crime, to countermand payment made with an electronic purse. And further, an even more basic reason why the issuer would prefer not to become involved in the underlying relationship is that there is no relationship between the issuer and the supplier. This is in stark contrast with the position under a three-party credit card, where the issuer, in other words the bank, binds itself to the supplier to pay the debts resulting from the use of cards issued by the issuer. Now let's consider a further issue that may arise from the use of smart cards and e-money. Issue number 2 is the physical loss of the electronic purse. What happens when the cardholder loses the electronic purse? To answer that, the stored value on it will also be lost in the same way that cash would be lost. The South African Banking Code of Practice provides for a wide variety of issues relevant to the banker-client relationship, including a number of provisions dealing with the phenomenon of digital cash or e-money. For the purposes of interpreting the code, the concept card includes any plastic card which may be used to pay for goods and services and to withdraw cash, but excludes electronic purses. An electronic purse is defined as any card or function of a card which contains real value in the form of electronic money which someone has paid in advance, some of which can be reloaded with further funds and which can be used for a range of purposes. In the South African Banking Code of Practice, clients are cautioned to treat their electronic purses like cash in a wallet. They are warned that they may lose any money left in the electronic purse at the time it is lost or stolen, just the same way as if they lost their wallet. They are further cautioned to protect their account, in other words, by taking care of their cards, electronic purse, PINs, passwords, and selected personal information. The code further provides that it is essential that banks are informed as soon as the client suspects or discovers that his or her card and/or electronic purse has been lost or stolen. The code provides that in the event of the loss of electronic purse, the bank must be notified of such loss and must acknowledge receipt of such notification. In such a case, the bank will refund its client the amount of any transaction, together with the interest and charges where money is transferred from the client's account to his or her electronic purse after the bank has been informed of the theft or loss of the purse. If the client acts fraudulently, he or she will be liable for all losses suffered as a result of the loss or theft of the card or electronic purse. If the client acts with gross negligence that has resulted in him or her losing the card, the client may be liable for such losses. failure by the client to comply with the guidelines provided for in paragraph 7 of the code may constitute such gross negligence. Further, the bank is willing to refund the client with any amount of the transactions along with the interest and charges associated with the disputed transaction. However, the bank will not make this refund if the clients inform them that someone knows the client's PIN, password, or another personal identification, which was a unique means of identification. From these provisions, it is clear that, under South African law, a client who loses his or her electronic purse will be in the same position as if he or she had lost cash. However, where the client has informed the bank of the loss of the electronic purse and the bank has acknowledged such notification, the bank will not be allowed to transfer money from the client's account to the electronic purse. The final issue that we are going to discuss is the absence of legislation. There is at present no legislation in South Africa that deals directly with either payment cards or e-money. There are acts that have general relevance for e-money. The Electronic Communications and Transactions Act 25 of 2002, which are referred to as the ECT Act, provides a wide and general framework for the facilitation and regulation of electronic communications and transactions, including electronic transactions for financial services, but it does not deal exclusively with electronic banking services. There appears to be a number of issues surrounding the use of electronic banking products, which are not necessarily covered by the provisions of the ECT Act. The Regulation of Interception of Communications and Provisions of Communication Regulated Information Act 70 of 2002 is another example of a statute that may have general relevance for electronic banking. In the absence of dedicated legislation, the issuers of payment cards and e-money, which in South Africa at present are only the banks, unilaterally determine the rules and procedures by which cards and e-money are to be used. Until regulation is put in place by the South African legislature, the relationship between the issuers of e-money on the one hand and the users of such e-money on the other hand will be regulated by those few provisions of the ECT Act that apply to electronic financial services, read with the common law principles of the law of contract. At this stage, it is only banks that provide electronic transfer services. Because the relationship between a bank and its client is generally in the nature of a contract of mandate, the rights and obligations flowing from the contract of mandate will apply to the relationship between a bank that provides electronic fund transfer services and the client who makes the use of such services. This brings us to the end of today's lesson. We hope that you found it helpful and informative. To put the lesson into context again, this was Lesson 9, Part 3. There is Lesson 9, Part 1 and 2 already available. We wish you well with your studies.